arrangement. So the topic of our talk is guardianships, and we pose this as how you can fix your guardianship system. I am the director of the Center for Elders in the Courts at the National Center for State Courts, and we work on adult guardianship issues and elder abuse and neglect and exploitation. And I'm here with the folks that are representing the two states that are by far leading the nation in terms of guardianship reform. And we wanted to start this session by talking about, we talk about fixing it, but what is broken? So I wonder if Cate and Jeff can talk about some of the issues that they see locally in Minnesota and in Texas.
So one of the, in Minnesota we audit conservatorship accounts, and we often have interesting findings in those audits. There's not a week that goes by that I don't have one of my auditors come into my office and say, "You're not going to believe what I saw now." And so I'm going to give you an example of one of our most recent cases that happens to be probably the highest dollar amount that we've found so far, and that's about $500,000 in loss. The daughter was conservator for dad, who was in a VA home, and she helped herself to about $300,000 to support her business venture, which failed. She also was the power of attorney for her mom and used dad's money to help out mom, which also included addition to her family home to the tune of about $200,000, which, by the way, mom lived in for a very short period of time, and included a garage. So I'm not sure what mom needed the garage for. That's an example of one of those very egregious cases. So if you're not looking, you probably haven't found that case, because if we hadn't looked at the accountings, it never would have been brought to our light. So I think that's something really important to keep in mind as you're thinking about guardianship conservatorship in your state.
Good afternoon. My name is Jeff Rinard. I want to first start off by thanking Cate and Brenda. They're actually leading experts in the country on what we do. Minnesota is something that we want to be in Texas, and we're trying to get to that point. And we're working our way through all these different steps to get there. So they're where we want to be, and we're kind of trying to be the model of how to get there. So I want to start off by saying a few things that we've found while we've been doing our project over the past year and a half. One of the big things we had when we first started with this project, we looked at a transfer case from New York, and they had transferred down to Texas. And we looked at the case, and we were just looking at it because it was a transfer case, and we were a new program. We're trying to figure out what we're doing and how to look at these cases. In this case, and just superficially by looking at the case, opening up the file and just looking through it, the case had been transferred down, and she had a significant estate when it came down to Texas. And it was really easy to see. Number one clue that we had, no filings had been reported since 2010. So nothing had been done. So we looked a little bit deeper, and we realized there was an $89,000 withdrawal out of the estate with no court approval. Nothing had been documented. And so we also had a $12,000 payment to a Ford truck, $18,000 credit card payment, all on this one estate with no court approval. And the guardian is nowhere to be found, and the ward was nowhere to be found. I have 3 or 4 pages of examples just by looking through the case files and just by looking and seeing what's happening throughout the state. We've only been in 20 counties so far out of our 254 counties in Texas. One of the other big things that we found in Texas, we found 2,300 deceased people who were under the watch of the court. So they're being reported to OCA as active guardianships, but they're actually deceased, and the court had no idea they were deceased. And some of them have been deceased, and this just didn't happen in the past few months. They've been deceased for several years. So it's pretty astounding that 2,300 people are dead and being reported as active while they're under the court's care. So those are just a few things. There's many more, but just be careful what you get when you pull the curtain back, because you might not want to see it.
there are 3 people up here, and we are extremely passionate, and we could talk for 24 hours straight alone on guardianships. So what we're going to do is try to go through this, and then you can ask questions later. But the problem of data is one that is widespread, and we're going to talk a little bit about what we have found nationally and then go to each state. By a show of hands here, do you know if your court, if you can identify the open active cases? Okay, now go back to the court and actually do that. I really do challenge you to make that happen, because once you start looking through it, I suspect that many of you will not be able to identify the open active cases. So we've gone out periodically at the state level, asked for basic data. This is data that they're supposed to have acquired and report to the NCSC's Court Statistics Project. So these are not new requests. We went out again last fall looking for data, and we wanted, it was part of another project, so we needed 4 pieces. 2 of those pieces are pieces that we ask every single year. The number of filings. We're looking for filings on adult guardianship and conservatorship cases. So the majority of states can give us that number. Then we drop down to how many open active cases. So if you think about the caseload here, some of these cases are open for decades. Do you really know what's open and closed? If you're not tracking this, you likely have a pretty poor sense of how many are actually active, and there are a lot of reasons for this. One of those is if you close this out, somebody's been appointed, you close it out on your database, on your case management system, who's monitoring it? Who's monitoring it? Are these cases coming back? So the best guess that we have now nationally is that we estimate that there are 1.3 million active adult guardianship or conservatorship cases in the United States. And it says "or" because a lot of people can't tell us whether it's a guardian of the person or a guardian of the estate. In fact, we spoke with, I had a phone call with somebody at the state level in a state that shall remain nameless, but she said, you know, I'm looking through some of the orders, and even in the orders, I can't tell what this person is responsible for. Is this a guardian of the person? Is this a guardian of the estate? Is this both? I can't tell from the order. So you have a lot of data issues. That 1.3 million is based on the 11 states that could give us accurate data on open active cases. That means that the majority, the vast majority of states cannot give us this number. The other piece of basically, we've got that piece, and everything initially really happens at the local level. So, you know, there are a lot of states that are not unified. There are a lot of states that practices vary from not just one court to another, but from one judge to another. So we are coming out, hopefully soon. It's under review from the Office for Victims of Crime, but it includes data and the impact of data and the lack of data on victims, because if the local courts don't know what's open and what's closed, think about it as if it's your parent, your family member, they can't tell the caseload what's open or closed. Who's monitoring what's happening to your family? So these are you know, continuing serious problems that impact most local courts.
So to talk about data in Texas, we get data, and it's not accurate. We have when we started our project, we had 54,000 active guardianships reported to the Office of Court Administration. And just to give you a little bit about how Texas is set up, we have 254 counties. In 10 of those most populous counties, we have 18 statutory probate courts. In those courts, they have specialized judges who deal with guardianship matters. They have investigators and auditors and court personnel who deal with these cases on a routine basis. On the other 244 counties throughout Texas, these cases are handled by the county judge, who sometimes is not law trained, or the county court at law judges who have other dockets and other things going on. So throughout, and you'll see a minute from the data that we've collected, the inaccuracies in the data that comes into OCA. We found already, I think, 12,000 cases that are not active due to being deceased, minors aging out, and other issues reporting to the office.
So in Minnesota, I am proud to say that I do believe we do have accurate data. We have conservatorship of the estate and guardianship of the person. The numbers that you see up there are regarding the number of conservatorships we have, and I can also provide accurate data on the number of guardianships. We weren't always there. We started in about 2011 doing cleanup to our case management system. We're quite unique in that we are a unified court system, although we do have 87 counties that have 87 ways of doing things. We have moved in the direction of a lot of consistencies, driven by technology mostly. And I would say that because of the processes we have in place, the court administrative processes, court staff from around the state do handle these cases very similar in all of our counties, which leads us to be able to look to see the number of open cases we have at any time. We have automations in our case management system that help us monitor the compliance of filing, and but we have gone through some very painful steps to get to that. And you know, a lot of case cleanup, a lot of manual work, right where Jeff's team is at right now. We've definitely been down that road. But I highly recommend that you open that dark curtain and take a look, because if you don't, it's gonna bite you.
I just want to add one thing to what Cate said. They have a unified court system. We don't, and they have one case management system. We have 14 case management systems in those 254 counties, and a lot of the counties don't have any case management system. So when we're reviewing these cases, we're not looking at index files. We're pulling out files off the shelf. A lot of these counties also cannot even provide us with an active list. So they're reporting a number to OCA. So say they're reporting 200 cases. We go out to the county, we get there, they can't produce that case list. They don't know how they're reporting that number. Somebody in IT is reporting that. So then they give us another list, which isn't accurate, but because the dates don't go back far enough. So what we end up doing is just going through case files from the 1970s, trying to figure out if there's active cases and cases that need to be closed, and finding the active cases for them. So it's a lot of intense work.
So each of you have, you're representing the state, and you're going into local courts to, first of all, sort through files and figure out what's open or closed. I wonder if both of you could speak a little bit about, the receptivity of local courts and local judges to having folks from the state level come in and basically review what's been going on.
Well, I could say that it is sometimes difficult for a state court program to come in at the local level and say, what are you doing, how are you doing it, and maybe you should do it this way, or you should do it this way. In these cases, I think it's rather unique in that all the local court staff were very concerned about their ability to look at and review these cases. I have heard from time and time again, I'm not an auditor, I'm not an accountant, I'm not skilled to look at this information. And they're absolutely correct. They don't have the accounting skills or the auditing skills to review the documentation, and they want to do it right. One of the things that the statewide CAP program has provided is a centralized clearinghouse of information and sharing of information amongst all our courts to help them work these cases correctly. And then, of course, we have audit staff that do the audits on the cases. So it has taken the burden off the local staff, and I would say that they've been very receptive.
And we've been in 19 counties now and 29 courts. We had some isolated incidents. At first, they were a little bit suspicious of why we were there. We have people who we call auditors they're auditor for us, but we call them guardianship compliance specialists. We've been really working with them to let them understand this is a service we're providing, so they know that what their active caseload is, what their closed cases should be, and how to handle those cases. One of the things happened in one of our bigger counties, actually a statutory probate court. They had 8,900 guardianships reported to us. So you can imagine, that's one county, 8,900. And we went in there, and the clerk was very resistant on letting us come in. Basically, I talked to him on the phone, I had to email him, and he made me send him a letter through the mail. I don't know if anyone does that anymore, put a stamp on a letter, but I had to send the letter to him and then wait for his response in the mail and then go meet with him and jump through all these hoops. But when we got in there and they figured out, oh, okay, well, they're working with us, and we figured out that already we figured out 3,000 of their cases are not active. So, and a lot of that was the clerk, because they weren't closing cases that were actually had orders and were closed out. So another incident we had recently, we went into a smaller county, and the clerk was actually at a conference, and she left this AG opinion for us, and it was highlighted in yellow, and it basically said, the clerk has no obligation to pull the files, and the information in the files does not have to be accurate. So those are a couple of little things that we found out. I thought that was kind of funny that they would leave that for us when we're coming out there. And that's one of the cases where we actually had to look through about 1,000 cases and pull them out and find them ourselves. Yes, ma'am.
Would you be willing to just come into one county, or do you have to implement within the whole state?
We were funded to do this guardianship compliance project. We have actually it's been a voluntary basis. So I've been going out and talking to the courts and clerks and trying to get them to do this. And one of the things that's happened is we've had a shift. So instead of being suspicious, now they're lined up. Now we have too many counties, and we don't have enough people. We only have 3 guardianship compliance specialists. So it actually shifted, because I think the way we handled it and the way we were providing this service, and we were non-confrontational. We provided a report to them, and we provided the information to the legislature, because they need that information to make decisions about stuff. But what I think happened is, I think that switched, so they know we're helping them. So I'm just, as they come to us, we're doing them one-off now.
I would love to do it, but I just don't know about my other cohorts in Michigan,
Yeah, you definitely have to have some funding for a few people to do it, and it takes a lot. They're out there looking through files, and in Texas, it's a big state. So to give you an example, we're in Amarillo, which is the panhandle, all the way down to Brownsville, which is the furthest point south in America almost. So, and anywhere in between, and it takes you 8 hours to get to Amarillo. So we're going out there, and it's expensive. I think we've spent $50,000 on travel this year alone. So yeah, it's a lot of work.
So let's get to the next data point. Money. How many of you can tell me, if you went back to your courts, can you give me that number? How much money is under conservatorships? Yes.
$5.5 billion.
Where are you?
Texas.
Well. Okay. You think you could?
Wisconsin, yeah, I could bump it.
Is the data in a database, or do you have to go through files?
The data would be in our case management system. When we get an annual account, we code it in as that, and then we put the amount in. So we generate next year's annual account. That's their starting point.
So how come Wisconsin can't give me this number?
I don't know why they can't.
Okay, let's follow up on that, because they are not able to give us this number. In fact, there are only 4 states that can give us this number.
That would be Clerk
And again, this is a number that people are making up right and left. So we thought, if somebody's going to make it up, let the National Center for State Courts make it up, because honestly, you see a lot of anti-guardianship reports in various newspapers, and some guy in Florida came up with this preposterous number based on the average wealth in Palm Beach County. So it's like, and I see this number quoted here and there, and it's like, okay, we're going to get whatever we can get from the states, try to extrapolate. So having done that, and having said that, there are only 4 states, 2 of those are here, and even Texas is wishy-washy yet. I I tell Texas they find $1 million every single day. It's one of those oil barons, and so I think your number's probably going to continue to rise. But we estimate that there's about $50 billion of assets nationally. And since I mentioned Texas, Jeff, do you want to talk about your estimate?
And again, Minnesota's where we want to be. She can give you an exact number. We're giving you an estimate based on the data that we're pulling out that's incomplete. So we're looking at inventories that are there and taking that number, multiplying it times the number that should be there, and coming up with something for the National Center. We think it's pretty close. I think it's pretty close, but there's some huge estates under guardianship, as you may or may not know. One of the judges brought one to me that it was a $67 million estate, and we see these multi-million-dollar estates, daily. So some of them have nothing, but there are very large estates throughout the country.
So as Jeff mentioned, and you can see from the slide, we can report to the penny the amount of assets under court jurisdiction because we gather transactional level data into our My Minnesota Conservator system from conservators. It is based on what they report, though, which isn't always accurate, as we find during auditing. Our number's lower than Texas because all of our senior people moved to Texas. I used to be a tax auditor, so they also moved to Florida and Tennessee and South Dakota and other tax-free states. But I think this is something that if you are interested and should be interested in reforming your guardianship program, and as Brenda said, we're all passionate about this, this is the number that you need to take a guess at, your best guess, because this is what pops eyes open. That's what happened in Minnesota. When we were able to come up with a number, we got attention. Because if nobody's looking, I can guarantee you somebody's taking the money. There is no doubt. And if you're not looking, you won't know. So if you can find out how much money is under court jurisdiction, even a guess, an accurate guess, then you will get eyes opened.
Jeff, do you want to talk about this?
So, of course, again, this is where we want to be, like Minnesota. Transactional level data is something that we do not have right now. Like I said, we've been looking through files, trying to figure out what's out there and what we do, what we can come up with and report back to the courts in these counties that we've been in, these 20 counties. So looking at these 18,000 cases, we've been able to determine that pretty much every court does something a little bit different, and it's a different situation in every court. We're developing an online system where they can report the annual accounts and inventories and annual reportings online, and they can do that in a very easy way. We're also working on a situation where all the guardianships in Texas have to be registered with us, so they'll have to take training and have their criminal background check done and come to us and have a registration. So we're getting to the point where we're collecting data, and we're going to have this data without depending on the courts and the clerks to give it to us.
And I have a brochure which is conveniently located back here on our Conservatorship Accountability Project, but I want to emphasize the importance of transaction level data. What we have been able to do is take over 1,300 audited cases from Minnesota. They use an auditing level from 1 to 4, with 4 meaning a concern of loss. We have taken all of that transaction level data and we have filtered it through all this incredibly fancy statistical analytics, and we have built a predictive model, and that we are able to accurately predict 80% of those level 4s automatically. So imagine if you could target what few resources you have on those subset of cases. If you do not collect transaction level data, you've got garbage. We have nothing to look at. You have to hand by hand go through each invoice, each statement, enter it into a database. But this is where we're going into the future, to try to use differentiated case management. Try to use the data, the empiricism, so that you know who to target. And by the way, those risk indicators are not at all what you think of as your red flags. So Minnesota uses those red flags. They've been based on anecdotal information. We ran the statistics, and the indicators are things that we never would have considered. So for example, if the accounting comes in and someone has more than 6 clothing transactions, they're more likely to fall into that level 4. Things that you would never have checked for. The size of the estate didn't matter. And a lot of these things that we're finding are maybe, death by a lot of little cuts. What is that great term? Death by thousand paper cuts. Right, so it's, they take a little bit here, they take a little bit here, and pretty soon, they're buying all of their own clothing out of it. But the empirical data, the transaction level data, you can catch them, and you can catch them electronically. It's not perfect, but this is where we want to move in the future. So that is the importance of collecting transaction level data rather than just beginning and ending balances. And even, if Wisconsin, if you can tell me what your inventories are, your inventories, from accounting to accounting are going to change. So, hopefully that, that has got to be all tracked.
One thing I will say about the gathering the transactional level data, it is burdensome to the guardian or conservator entering it. It is. There's no doubt about that. It takes time. But we also have the ability to download, so it can be downloaded from bank statements through a spreadsheet, or it can be entered one transaction at a time. And the system that we have in place gives them tools to manage the assets too. So there's some benefits to the actual guardian or conservator.
So now we're going to move into a more subtle, smaller level of data. Can you tell me how many of your annual reports, annual accountings, if you do have an annual system, how many of those are submitted on time? Can anybody tell me that? Texas can. 14%. Jeff is going to correct you in a minute, I suspect. But these are vulnerable people. We're in charge of their assets. Somebody's got to do a report, and we're not even checking off and tracking whether the report's been submitted. What a joke. Excuse me, what a joke. I mean, I've worked in multiple systems, worked on domestic violence issues, child abuse and neglect, and the amount of neglect on guardianships is abhorrent. It truly is. I mean, I'm glad that you're all here because, again, I'm starting to feel my passionate piece come out. But this is basic information that you've got to begin to track. You should be tracking now. And so, are you able to send automatic reminders? We found that there's inconsistency from judge to judge on when an annual report is due. Is it at the time of appointment? Is it at this time? Is it at the time I sent the letter? So you're going to find out if you go back in that there may be inconsistencies even at that very front end. And once it is submitted, who's reviewing it? I mean, that's going to be the next piece. But right now, it's just compliance. If you can't figure out your compliance level, I mean, that is something that you need to collect, and that can also be used to say, I need resources. Do you know we've got $5 million, we've got $50 million, we have whatever it is, and we don't know, we have no accountability for what's happening to those funds. So Jeff, you want to talk a little bit about compliance?
So in the 19 counties we've been in, the 18,000 cases we've looked at, 5,000 or so have been active, and 40% of those are out of compliance. So 40% of those 5,000 which were active are out of compliance with reporting the inventory annual reports and annual accountings. And not to mention, we don't count those dead people as out of compliance. We count them as closures, which I think we're going to change that because I think they're out of compliance if they're deceased and no longer with us. But one of the things that we've been working on is really getting with the court. They're not managing the cases and sending out these notices on an annual basis. So if they're not sending out notices, if someone's not asking them to comply, they're not going to comply. So just for an example, one of our counties, they hadn't reported in 8 years. So all we did was send them a letter because we've been producing letters for the court as well. So once we go in and we find these delinquent notices or delinquent reportings, we'll create a notice and send it out. And they respond back right away just because of this notice. So they hadn't responded in 8 years. We send them one letter and all of a sudden they're back on board. So it's just something that takes a little bit of effort to get them to report.
So as far as compliance with filing, we kind of have two pieces in Minnesota. We have the guardianship piece, which is still filed on paper by the guardian, and then we have the conservatorship annual accounting, which is filed through the My Minnesota Conservator System. So with the conservatorship piece, because of the integrations between that system and our case management system, we have a lot of automation. Reminder events are automatically set out. Reminder events are automatically completed when the annual accounting is filed. And court staff run reports on those non-completed reminder events so that they're on top of the compliance level for the conservator. The other piece is within the application, there are soft reminders that go out via email and on a notification tab to the conservator on a regular basis. So reminding them that their date's coming up, et cetera, that they need to file on a constant basis until such time that they file. And then we send them a congratulatory email saying, thanks, you filed, yay, now start working on your next year. On the guardianship side, we don't have that. We're in the process of building that into our current system. We have seen significant increase in compliance on the conservatorship side because of that automation. So we're hoping one of our goals is to gain that from the guardianship side when we go to automation there.
So we've gone through open cases, and we've talked about the money dollars, you know, the data with data points, how much money you're tracking, and we've talked about compliance. So all we've gotten to the point of is whether they're submitting. We're not talking about the quality of their submissions and whether anybody is possibly reviewing it. So that is this other piece of monitoring. Now, I also staff the Conference of Chief Justices, the Conference of State Court Administrators, Committee on Elders in the Courts, and we work very closely on guardianship issues. And I've had this discussion with the Chief Justice of North Dakota. He said, you know, and he's very passionate about this, he said, the issue is we are required to make sure that they file, not necessarily required to review what they have filed. And so you find this fine line in the statute, and so some places there is no real mandate, and others, what is a review? Okay, it's January to December, yep, it's all here, okay, I've reviewed it. So what we're really going to talk about is monitoring, and how do you track for, how do you find out if somebody is stealing, how do you really monitor these cases? And again, this is not going to be a surprise to you, because resources is an enormous issue. Most courts don't have specialized auditors or accounting specialists or folks who are even charged of looking through the accountings to make sure that the documents are correct. Now, several years ago, there were, anybody here from Nebraska? No one from Nebraska. So the Omaha papers really tracked down a case of a professional conservator who was stealing funds over and over, different cases, different judges, and that court had a volunteer program, a volunteer monitoring program. So they had some retirees, and the job of those retirees, the monitors, were to check the math. So, yep, things add up. Nope, things didn't add up. That was really the extent of what they were doing. Well, this case of this professional conservator who stole hundreds of thousands, if not millions of dollars, things added up, but they just always ended with zeros. So, you know, it's pretty hard to go shopping and have something come out as $10 exactly. But to have something like that happen over and over and over again, that's remarkable. That is just incredible. So again, even if you have a level of reviewers, they may not be trained on what it is they're looking for. So that's a case where had a volunteer monitoring program. That conservator, the math was checked, everything was good. Boom, let's give you another case. So it is critical that you've got trained staff and that they, you know, that there are some resources devoted to this. But I mean, I think one of the things that we have discovered, and we probably won't be able to say it enough, is that even when you don't have the resources, there are things you can do, and so much of this comes down to the simple element of leadership. So I'll just go through your slide, this one very quickly so that you can elaborate, but in Minnesota, 13 of the cases were audited and had concerns of loss, and in Texas, they're looking at out of compliance, so that's 39%. And so, Cate, if you want to talk about more of that 13% and what it is you guys do.
So we have a statewide conservatorship auditing program. Our statute requires that we monitor. That's the term that's in our statute. And our state court has taken that to say that we will audit cases. We are not able to audit every year just due to staffing concerns, but we started in 2012. Upon the completion of the audit, the auditor issues a classification. A level 4 case, or that 13%, are cases of concerns of loss. And we report that to the court in an audit report. And then a hearing is held to address the findings of the audit. What the auditor does during the audit is reviews third-party documentation. So they're not just adding it up to see if it adds up. They're looking at third-party documentation, financial statements, canceled checks, invoices, tax returns, HUD statements if there's property sales, all of those documents, making phone calls sometimes to nursing homes to see if bills are paid on time, and doing a lot of extensive research to determine if the accounting that's filed is accurately filed and if there's any concern of money missing. So my audit staff are all accountants. I have a CPA, I have certified fraud examiners, and I have 4 staff that are MBAs. So they're highly qualified. They testify in court at hearings frequently on their audit findings. And I think it's a very important piece of the monitoring of these accountings.
And Jeff, you want to talk about the 39%?
And so I've already kind of touched base on the 40% of the cases out of compliance. So what are we going to do about that? What we've had plans to do is we have legislators who are involved and they're very on board. We had a bill that was actually vetoed by our governor. It went through the House and our Senate to take our guardianship compliance project statewide and to add these auditors and assist the courts in auditing their annual accountings and bringing in these annual reportings through our electronic system that we're developing. So what are we going to do in Texas? We're going to continue doing it. We're going to continue doing our guardianship compliance project. We're going to fund it through the OCA. We're going to continue developing our online reporting system. We have an in-house programmer who's developing that. We're working with NCSC and the CAT program to do that. We're going to register all guardianships in Texas. That bill did pass, so we're going to start doing that and doing the background checks and the training video. So we have a lot going on to fix this overall problem, and hopefully we'll get the funding for that sometime in the future.
Does that include training your conservators so they know how to put this information into the system?
The guardianship training is about guardianship overall, guardianship of the person and the estate. But when we do develop the system, we will have a training, and I believe Minnesota has a YouTube video on how to put the information into the system as you go.
And I'll discuss training as one of the resources that we are developing. So let's say in all perfect circumstances, you catch the fraud, you catch the exploitation. The next question is, are there consequences for those who exploit the system? It's obviously a lot of people are escaping, and we don't find them. But once we do, what happens? So we were able to look at the Minnesota data, and we followed up on a set of their level 4 audits. And we wanted to know what happened. So these were the most serious results in terms of the audit. These were concern of laws. And I don't have my data in front of me. This is all brand new, like we just submitted the report Friday. So my head is swimming yet. And I think it was 31% of the level 4s we deemed as exploitation because the judge did something like ordered assets to be restored, the bond was called on. But there were some of these level 4 audits where the judge did nothing. The judge did not even hold a hearing. And so we piggybacked to that data piece and thought, well, let's talk to some of the judges. So we called 6 of the judges who had found, at least in one of those cases, some level of exploitation. And what a difference, what a variance from one judge to another. So we had the one specialized judicial officer who said, here's the statute. The statute says the court's responsible for monitoring and can do anything that we deem appropriate. So yeah, I'm going to try to get the funds returned. I'm going to try to do this. I'm going to try to do this. We talked to some of the other judges, mostly general jurisdiction judges, and they said, well, that statute, it's really vague. It doesn't tell me what I can do. So it's the same statute. Some judges, especially those who are really well trained in probate, are saying, the court's accountable for this. I'm going to take action. The other ones are basically waiting to be told what it is they should do. We interviewed the auditors, Cate's auditors, and more than one of them said, I've testified on this case, and the judge turned to me and said, what do I do? There's no guidance on this. There's absolutely no guidance nationally. That's true. So one of the outcomes that we found from our conservator exploitation project was that basically the estate is plundered prior to the detection of a problem. So the money's all gone by the time a problem is detected. So the consequences, and what are the consequences of not having basic data, and not having the ability to monitor? And I think, Cate, you were going to talk about average, typical types of cases and what can happen.
So part of the outcome of the project that Brenda was just referring to is we've identified kind of the typical case of exploitation. And the victim is typically female and under 65. The conservator is typically family. And I think this piece is really important data for me. We have a statute that requires bonding, but a lot of our judges waive bonds when it's family members because, oh, it's family. Well, this is my statistic that I will take to my judges to say conservators that are family are the most likely to exploit in the cases that we have. So I think that's a really important piece. And I think because we're the only ones that have data and we're the only ones that this project has been on, you can take this data home to your judges too. And then the court action. This has been a really frustrating piece for us because there's discretion and our courts vary tremendously on what happens. From discharge to removal to orders for judgments to be repaid to nothing. We've had I think in the history of the program, maybe 2 cases referred for criminal prosecution. So that $500,000 case that I talked about didn't get referred for criminal prosecution.
That's what I don't understand why the prosecutors don't go. I mean, this is a crime.
It's family.
It's
Your victim is a vulnerable adult.
Who has been declared incapacitated,
Yeah.
quite likely. So who are you going to believe?
It's a very complex, difficult crime. And my background is in law enforcement, so I totally agree. It's a crime. A crime is a crime is a crime, but these are difficult cases to prosecute.
Jeff, do you want to?
So we're at a different level at that. We're trying to clean up reporting and get judges to do things to get them to come into compliance. And some of the things that we've done is send out the notice. They've been having compliance hearings. They've been having show cause hearings. They've been removing guardians. They've been taking some action, and we're working with them. And like Cate mentioned, it's very inconsistent from judge to judge and court to court, even on writing the orders to close the cases. Do you do them individually? Do you do them by a mass order, and how do you do it, and what's the procedures for doing that? So we're trying to also develop procedures for the courts and clerks as we go as well. So we're more at a phase where we're building something and trying to get to that level, but doing those little things in between to get there are the things that are going to help us stop this at the end. So it's just something we're not there yet.
So I don't want to, leave you all on a really negative note, because this is an area of fantastic opportunity. So if you really want to make your mark on an area, this is open for you. We have some very ambitious plans because the current system can't exist as it is. I mean, I don't want to be. We had our conservatorship fraud meeting, and we had a victim whose father-in-law was exploited in Las Vegas as part of a larger scandal, corruption. And he stood up and he said, we've been talking about this for decades. Nothing seems to get changed. I don't want to come back here when I'm 73 and find that the same system is impacting me or my wife or a member of my family. I just can't have it. And so, I said, okay, let's fix this. I think we could fix a lot of this. So one of these efforts is to try to modernize the system. I mean, we're doing that. Cate's model in Minnesota, what Texas is doing, these are all huge advancements towards using technology, which I believe works really well on the financial piece. It's a lot easier to track people's money than people's health. But the resources are there. What we're able to do with that empirical analysis, that is very, very promising. So the conservatorship accountability project, I mean, we've got the software, which is being piloted in a couple of other states now. We've got the predictive analytics, and then it's the examinations and audits. So that's all part of the conservatorship accountability project, which is something that we want to expand and make easier for states and localities to implement. The other piece of this is, and we just got a new grant to develop a judicial response protocol, and it was really based on our experiences in Minnesota, where the judges said, well, what do I do? What am I supposed to do about this? So we are coming up with a national advisory group. Includes representatives from the National College of Probate Judges, the American Judges Association, the National Council of Juvenile and Family Court Judges. So we're going to have buy-in. And I'm kind of hand-picked this because I know which judges I want on that. And it's going to be trying to develop a proactive response, some guidance. While we each have different state laws, the laws on this, such as in Minnesota, are very vague. They give no direction to the judge. Pretty much wherever you have a bond, any judge anywhere can call out, can take steps to get that bond called. So there are some similarities. This is the conservatorship forum, which we just held last March, in which the report is still being, it's under review, and by the Office for Victims of Crime. But these were sort of the priority recommendations, and one of these at the very top is data systems and tracking. We've got to do not just a better job, we've got to do a good job. I mean, it's really stinks right now. So, we've got to do better at the data and tracking piece. The other thing that they recognize is there really aren't the auditing resources. Let's see if we can build some auditing resources. Another is the integrity and impartiality of the courts. There's a lot of concern by sort of the network, the little close network between the judges and the probate bar and buddy. I've seen that myself, and so there's a sense that the judges are in cahoots with the professional conservators, with the attorneys, and so this was a multidisciplinary forum. So we had victims, we had AARP, we had ABA, we had folks from Adult Protective Services, we had people from the disabilities community. Sense that we do need to reform state laws, make substantive changes, and then also judicial training. That is a need that runs throughout all of this. This is our current project. We're working on this primarily with the American Bar Association, with some assistance from the Washington courts. But have any of you taken NCSC, sort of these new online interactive programs? A couple of people? So we're moving away from the talking heads, and North Dakota is the first to develop this really fantastic program. It's all online and it's all interactive. There's scenarios. You have to pick and choose. What should I do? Is the best decision A, B, or C? Oh, well, maybe you should have tried this. It's really quite fantastic, and it's made for lay persons. It's made for family guardians and conservators. What do I do? What do these terms mean? What do I do when the person dies? I mean, it lays all of the groundwork. So we're taking that. We're also looking at the supported decision making, help people avoid guardianships and conservatorships with the alternative. So there's actually 3 pieces: the supported decision making, how does that work? The alternatives to guardianship, providing some basic means on other options that may be more appropriate. And then if you are appointed a guardian or conservator, what are the best practices? So that's a project that we are working on. It's funded from the Department of Justice. So we again understand that things change, the terms are different, the laws are a little bit different. You might have, but there's good accounting practices, there's good reporting practices, there's good decision making, there are standards, there's National Probate Court standards, the National Guardianship Association has standards. There are national standards, so we feel that it's about time that we kind of develop a national resource so that every locality doesn't have to go out and, I guess I gotta make a videotape to help these people, figure out A, B, and C, because the training for guardians and conservators is generally very poor. Here, watch this, take this hour course, and now you're all set to handle somebody's money. It better not be my money. So that is where we're at now. We also just submitted a proposal. I don't know if it's going to be funded. I certainly hope so, but we want to develop a guardianship app for judges. So when they're on the bench or they need the resources, they've got little checklists. They know, okay, well, if this happens, then I need to ask about the bond. If this, then that. So it's a proposal, but we're trying to move in the direction of modernization. And this area has been neglected for a long time, and There's interest. There's more interest than I've ever seen. It's not unusual for us to get a call from the Senate Special Committee on Aging. Cate testified with them in November. I testified in March on Social Security representative payee and how it can be connected to guardians and conservators. So there is federal interest, there's state interest, and if you're looking for an area to craft to be your own, to become an expert and do some good, help the people that you're supposed to protect in the first place, this is it. So any questions or comments? We've got 5 minutes.
Hi, my name is Sandra Aaron. I'm here at the
DC Superior Court, under Ann Meister?
Yes.
Okay.
I believe that we also have a very active guardianship. I mean, everyone that's bonded, family or no family. You know, they have annual filings. They have ticklers for reminders. They have a very active conservatorships and guardianships. And also, we also have what we have is Office of the Auditor Master. When there is a issue with the accountings or suggestions of maybe a misappropriation, it goes into that office. That office, we have subpoena powers that we can go and elicit documents from the financial institutions and find what the fiduciary may or may have not done with the assets of the wards. In that office, we make recommendations for judgments.
The DC Superior Court is very good, and you know, since I've got you on the microphone, I mean, because you also do a very interesting thing that you partner with. Is it the social work department? Is it at Georgetown or one of those?
Yeah, different schools, and then for the guardianships of the persons, they have these students that go out and investigate the care. They do filings, their reports to the courts, and they'll state whether or not the services that are being rendered are proper or improper. Depending on that, they can have additional hearings if there are findings of problems. They used to just kind of have these reports filed and no one really read them. Now they're reading them, and they're really monitoring much more closely.
Yeah, it's. I mean, when you work in this area, you get to know every single court and who's in charge of the good ones because they're like on my hand. And so the DC Superior Court does a very good job, but it also underscores, so their former Chief Judge Washington actually did the introduction to what's called WINGs, Working Interdisciplinary Networks of Guardianship Stakeholders. Everything here comes down to leadership. And I think Jeff and Cate can emphasize how critical it is for the chief judges, the chief justices, the state court administrators, how critical it is that they, you know, not just support, but get actively engaged. That's how this changes.
Oh.
You were saying that you want to start this better education for family guardians. What about professional guardians? Professional
Guardians, many states are moving towards certification and licensing, and they should at least be a member of the National Guardianship Association, and there are resources for them, so they can, where are you from? Florida guardianship issues are in the news every other week, and
And I understand why. I mean, for professional guardians, there are no minimum education requirements.
Yeah.
You can go.
Yes.
You can be
18 years old. Yes.
And go take a class for 40
Yes.
hours and pass the test, and you too can be a guardian.
It is,
Yes. Someone's
yes.
money in their life.
In Minnesota, we don't even have that. We have no certification whatsoever. A professional guardian or conservator is defined by somebody that has 3 or more people not related by blood.
Well, see, ours is 2 or more, not really. But
We do have a movement to have mandatory certification for professionals. That's starting, and Sally Hermie is coming on, I think it's July 21st, to talk to our Professional Conservator Association regarding that. But one thing I will tell you is we have had 2 significant cases in Minnesota of professional guardian conservators that have stolen money. Both of those were certified. On their own accord, they certified themselves. So yes, I absolutely agree that not just anybody should be able to do this work, but it's not going to stop exploitation.
It's not going to stop it. But one thing that they should be doing, especially like in Florida, if you're a professional guardian in Tallahassee, you can also have clients in Key West.
Mhm.
You can have as many clients as you want.
Yeah.
Okay. There's no comparison of billings. So, in my opinion, judges are operating in a vacuum. when they approve
Absolutely.
a guardian's fees. So, we went through. We had one guardian that I knew just from looking at a few of her billings. I knew she was overbilling. So we went through and looked at all of her cases, took all of her hours from the year 2000 to 2013. We added them all up. She worked a 41.8-hour day. There were several days she worked more than 24 hours, but
Yeah.
41.85 was the
Yeah.
most.
All of the states that have done reform, many times they have found somebody who operates in multiple counties, and one county doesn't connect with the other, and nobody
Right, they
knows
don't.
what's going on. And the value of having a database too is that you can look at fees. You can look at fees per case. You can look at fees for professionals. You can see what the norm is. Right now, it's, what's the criteria for fees? Are within reason?
Reasonable?
Everybody's reasonable.
Right, and it is an area of exploitation, but there are many areas we could use your help. It's just, yes.
Yeah, in Minnesota, you mentioned the transactional entry of is that mandatory by statute, or is it entered in each order?
It's now mandatory by rule.
Or by
It was
rule.
initially order from the state court administrator, and now it's in our court rules.
Another question is you talked about active and open. Do you have operational definitions in your state for what's an active and open case?
Yes. Yes.
Can that be found out online?
Actually, our court processes are not public data that is online, but if you want to contact me, I could share some information with you.
And the NCSC's Court Statistics Project has open and closed, and then they're recommending sort of a third category of something review, it's slipping my mind.
Under court review?
Under court review, so that, it can be closed out so the judge is happy because his or her, case is closed, but it's under review, that this is supposed to be, the reports are supposed to be reviewed. So that is something that we recommend.
That's what we found in our court, is that they're being closed, and yet there's reports coming in. We started doing some things to
Right.
monitor the reports,
Right.
but
It seems, it seems basic, open or close, right? This is not that type of a case.
It's a unique case type, because once the order is granted and the letters are granted, the case starts.
I think I'm getting the signal that it's happy hour. Patty's here, it's happy hour. So thank you all very much.
Thank
It's
you
been a
very much.
pleasure.